avoid any interruption during the seminar. Ladies and gentlemen, the opening ceremony of International Seminar, the regulation of data laws via international trade law, will be started shortly. Om Swastiastu. Good morning, distinguished guests. Ladies and gentlemen, welcome to the International Seminar, the regulation of data laws via international trade law, held by Master of Notary Program, Faculty of Law, Udayana University. Her Excellency, Vice Dean for General and Financial Affairs of Faculty of Law, Udayana University, Dr. Anak Agung Istri Ari Atudewi SH.MH, Coordinator of Master of Notary Program, Faculty of Law, Udayana University, Dr. Imade Subawa SH.MS, Coordinator of Master of Law Program, Faculty of Law, Udayana University, Dr. Gedemade Swardana SH.MH, Coordinator of Doctoral Program in Law, Faculty of Law, Udayana University, Dr. Ibrahim SH.MH, Coordinator of Bachelor of Law Study Program, Faculty of Law, Udayana University, Dr. Subahak Karmaresen, SHMKN, Honorable Moderator, Ms. Nigusti Ayudiah Satyawati, SHMKN LLM, and all distinguished participants. First of all, let's praise the Almighty God. For His blessing, we are able to attend this international seminar, the regulation of data laws via international trade law, held by Faculty of Law, Udayana University. Today, Friday, June 18, 2021, at Aula Faculty of Law, Udayana University, and through Cisco WebEx application. All blessed participants, let's begin our agenda this morning with a moment to pray. Ladies and gentlemen, please stand up. Praying moment is started. Thank you. Please remain standing. Let's sing the national anthem, Indonesia Raya. Thank you. Please have a seat. Ladies and gentlemen, to begin the opening ceremony today, Here is the report from the Chief of the Organizing Committee, Dr. Made Suksma Prijandini Devi Salain, SHMH LLM. Time is yours.
Om Swastiastu. Good morning, the Honorable Vice Dean for General and Foreign Affairs, Faculty of Law, Udayana University, accompanying with Coordinator of Master of Notary Program and other study program coordinators. Distinguished speakers, moderator, participants, and committee members of this seminar who are attending the venue as well as joining online. Praise be to God Almighty, because of His blessing, we can meet here together at the international seminar, the regulation of data laws via international trade law, which is held by the Master of Notary Program, Faculty of Law, Udayana University. First of all, allow me to deliver a report representing the organizing committee concerning the seminar today. We invite three speakers to deliver their remarks. The first speaker is Neha Mishra, PhD, a distinguished lecturer of the Australian National University, Canberra, Australia. The second speaker is lecturer of International Trade Law of Faculty of Law, Udayana University, Bapak Igusti Ngurah Parikesit Widya Teja, SH M.Hum, PhD. And the last speaker is Ida Ayu Agung Saraswati, SH, a student of Master of Notary Program, Faculty of Law, Udayana University. The moderator for this seminar is chaired by Ibu Nigusti Ayudia Satyawati, SH MKN LLM. This seminar is predominantly attended by lecturers and students of Udayana University and other universities, including foreign students. Besides, the participants are also representing government officers such as Dinas Perindustrian dan Perdagangan Provinsi Bali and alumnus. Offline participants are 50 persons, while online participants are 378 persons. Some participants are from Tangerang, Kalimantan, Surabaya, Mataram, Semarang, Surakarta, and Maluku. Since we have foreign speaker and participants, allow me, on behalf of Faculty of Law, Udayana University, to introduce our international program called Balinese Customary Law Short Course. It covers not only the issue of customary law in Bali, but also various related aspects, among others, business, environment, and human rights. More information about this short course program can be found on Udayana University official website. Lastly, I would like to express our gratitude to those who generously support the organizing of this seminar. And subsequently, I would like to invite the Vice Dean for General and Financial Affairs of Faculty of Law, Udayana University, to deliver a speech and officially open this seminar. Thank you.
Next, we like to invite Vice Dean for General and Financial Affairs of Faculty of Law, Udayana University, to delivering opening speech and officially open this international seminar. Time is yours.
Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Salam, Namo Buddhaya. Good morning, Your Excellencies, Vice Dean of Faculty of Law, Udayana University, Coordinator of Master of Notary Program, and other study program coordinators, distinguished professors, speakers, moderator, participants, chairperson, and the members of the committee of this seminar. First of all, allow me to express my gratitude to Ida Sang Yang Widiwasa, the Almighty God, because of His blessing. This international seminar can be conducted today. I was assigned by the Dean of Faculty of Law Udayana University to represent him in delivering a speech and opening this seminar. On behalf of the Faculty of Law Udayana University, I welcome you all, both who participate by offline and online means, to this international seminar. On this occasion, I would like to express my gratitude to all speakers who will share the available knowledge and experiences. In particular, I recognize the presence of a special guest speaker, Neha Mesra, PhD, lecturer of School of Law, the Australia National University, Canberra. Ladies and gentlemen, the topic of the seminar today reflect the ongoing public debates regarding the important role of big data along with its potential risks that are manifested in the draft of legislation concerning personal data protection. From private law perspective, notary may play a vital role in ensuring the secrecy of his or her client's personal data. This is why notary and those who are currently studying notary have to learn this issue. In a broader scope, big data is also a serious matter in the field of international trade law. Actors of international trade use various types of data that, if not properly protected, might potentially be misused by other parties. Therefore, the seminar today is expected to discuss how the international trade framework would adapt to the progressive use of data law. The topic of the seminar today reflects the ongoing public debates regarding the important role of big data along with its potential risks. Despite the concern on public matters, big data also approaches private issue. I strongly believe that this event will offer new insight and values of all of us. And lastly, I declare that the international seminar on the regulation of data laws via international trade law is officially opened. Thank you very much. Om Santi, 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 Om.
Please to remain on stage for photo session. We kindly invite all the coordinator programs, invite all speakers and distinguished guests. Thank you very much. That was the opening ceremony. Once again, we thank all of you for the participation and attention. As we have finished our opening to lead the next session, I would like to introduce our moderator, Miss Igusti Ayudhya Satyawati, SHMKN LLM. She graduated from Udayana University for her bachelor degree, continue her study at Master of Notary program, Gajah Mada University, and she also graduated from Maastricht University, the Netherlands, for her LLM degree. And now she is a lecturer at Administrative Law Department, Faculty of Law, Udayana University. She is also served as the head of the Center for Legal Drafting Unit. To Ms. Nigusti Ayudhya Satyawati, please come to the stage and time is yours.
Thank you very much. And I kindly invite the speakers, Bapak Vidya Teja and also Miss Dayu to join me at the stage. Thank you. And I also already see Miss Mishra already joined us through online. Okay, thank you very much for the committee. It's an honor for me to chair this session. The agenda for this seminar today will be divided into two sessions. The first sessions will be the presentations from the speakers, and the second sessions we will have the open discussion. Regarding to the title of the seminar, the regulations of data laws via trade law, a few minutes ago, the Vice Dean in her speech raising the issues about the political debate on the drafting of the national regulations concerning the protections of personal data. The one of the very controversial issues is about the risk of the personal data misuse and also about the incapacity of several relevant authority to ensure about the safetyness and also about the data that they manage. So with regard with the current situations that happen now related to the trade sectors, we can say that trade sector use various types of data because it's belong to the exporter, it's belong the data also about the importer and also about the products detail, the producers and also even the chains of distributions and of course the data of the customer itself. I can say that this is very important, the situation that it actually require a proper legal arrangement at the global, regional, or also, and also the bilateral level to make sure that those activities is really well regulated. So I think that's something that I can start to deliver before we continue with the presentation sessions. Before the presentation sessions, uh, please allow me to introduce our first speaker. And after the introductions of her curriculum vitae, she will deliver the presentations for today. Miss Neha Misra, BALLBLM, MPP PhD. What an honor to read your curriculum vitae. If I can say, it's like my dream curriculum vitae. I wish that I can have all your achievements. Thank you very much, Miss Misra, that you have time to join here with us to sharing your knowledge and experience. So. It's
her curriculum vitae honestly is very interesting and it give us a very a good how to say experience. If I can say, please allow me to read her education's background. So, uh, she finished her Bachelor of Humanities and Bachelor of Laws at National Law School of India University, Bangalore, India. And then she continued study at London School of Economics, London, United Kingdom. So she graduated there with for Masters of Laws in Public International Law, graduated with distinctions. Wow. And then she continued study to Lee Kuan Yew School of Public Policy, National University of Singapore, where she got her master in public policy. And she plays in the student's role of honor for 2 semesters. And then she continued her study at Melbourne Law School, University of Melbourne, Australia. And then she got the PhD in law with approved with no correction. So may we give big applause for her. Now, Ms. Neha Misra served as lecturer of Australia National University College of Law. But now I got an information from Pak Sigit that Ms. Misra joined with us through online in Tokyo. Is that correct, Ms. Misra? Can you hear my voice? Can you hear?
Yes.
Yeah,
Yes.
wow. Thank you. So, you are really a bright person. I adore you directly when I read your curriculum vitae and hope someday that I can meet you in person. Okay, so for this seminar, we will have like 20 minutes for you to deliver your presentations. And after that, we will continue with the second presentations, Bapak Widya Teja, or you may call him Pari. Yes, and then after the second presentation, we will still have the third speaker. And after that, we will open the discussion. So you will have like 20 minutes for that. And I know that you will have time only like 11:30 Bali time. So before that, we will finish all the questions for you. So you have time to make your closing statement also. So for Ms. Misra, time is yours.
Okay. Should I share the PowerPoint or how does it work?
Yes, we will share your PowerPoint because you already sent it to us, and maybe you can just guide us, like if you want to have next slide or yes. Thank you.
Okay. So good morning, everyone. Thank you so much for the very kind invitation from Udiana University and for such a warm and wonderful introduction. I'm really honored to be with all of you, and I wish the next time we can meet each other in person. So while the slides are being shared, what I'm going to focus on in my presentation is the interface of trade law and data governance or internet governance. And I'll look at 2 examples, privacy and data protection and cybersecurity. Now, certainly these are not the only 2 areas where you can see interface between the 2 fields. There are other areas, intellectual property, online content regulation, access to telecommunication networks. Of course, we can't cover all of this in a presentation, but I hope the presentation gives you a big picture of these 2 worlds and also probably gives you an insight into what you could be exploring in the context of Indonesia's regulatory environment. Can I just check if the slides are being shared? So can you please move on to the next slide? Okay. So the first question I just wanted to raise with everyone is why should we care about this topic? How is this relevant to the world? And there have been such excellent introductions by the honorable moderator and the about the importance of this topic. Let me just put it more succinctly in 3 points. One is that the economy and the world that we live in is really becoming digitalized, which means we are doing all kinds of economic transactions using the internet. And The current pandemic has actually accelerated the use of digital technologies. The fact that you and I can speak, even though we are in very different parts of the world, is a proof of that. And it's not just communication, but generally business. The entire global supply chain is now heavily dependent on cross-border data flows. And there's a lot of data you can find in regard to that, especially how data flows now is also not just relevant to services sector, but also to manufacturing. The second important reason is our lives have become digitalized. We all spend a lot of time with digital technologies, our smart gadgets, using cloud technologies. And as a result, the third important reason is, and this was again highlighted, that we are increasingly subjected to so many cyber threats and cyber risks. And we are not only conscious about privacy or cyber crimes, but we are also conscious about surveillance by big technology companies, and in some instances also surveillance by governments. Next slide, please. So there are three things I'll highlight in the remaining few, like 15 minutes or so of my presentation. The first point that I want to highlight is that although trade and data, they seem to be very distinct governance frameworks, when you think of digital trade, digital economy, you have to actually bring these two distinct fields together. And one such area where you can see this very prominently is the area of cross-border data flows, and some of my discussion will revolve around that. The second thing I want to highlight in this presentation, now I've already said there is an interface of trade and internet, trade and data, but what do we do about it? So what I will emphasize is that if we want to balance these conflicting objectives or these different objectives, it's very important for us to balance principles of trade liberalization, which you can find in trade agreements, the WTO agreements, FTAs, with internet policy objectives such as cybersecurity or privacy. And ultimately, this leads to a predictable, to a coherent, and to a certain framework for digital trade, which is so important in the world today. And the third thing, in terms of towards the end, I'd like to highlight is that, of course, while I'm identifying this relationship between trade and internet and trade and data, my point is not that everything should be regulated through international trade law. This is a very complex, multidimensional problem, and trade law should be seen as a part of the problem and a part of the solution. And part of the challenge for us is to figure out what the role of trade rules will be within this multi-layered framework. Next slide, please. Okay, so in this slide, I wanted to just show you at a very high level how internet trade and internet governance are coming together. Now, first is the world of international trade, and many of you are already aware. We have the World Trade Organization, or the WTO, which administers different kinds of trade agreements. And increasingly in the recent years, we have more regional trade agreements and plurilateral trade agreements. Now, the basic idea about trade agreements is that they contain several binding legal provisions, and often they are subject to dispute settlement. If you can just click once more on the slide. Just yes. The other world is that of data internet governance. Now, this is a completely different landscape. Unlike the trade world, where we have treaties and laws and dispute settlement panels, in the internet governance world, there is a very complex web of institutions, which means that it's not just government. There is private sector, civil society, standard setting bodies. A range of institutions are working together in their area of expertise, and they are usually not driven by laws in the same sense as the trade world, but rather there are many shared values, soft laws, fundamental engineering principles, high level policies. One change in the recent years in this domain is that governments are becoming more proactive, and many of you would have noticed, even in the Indonesian context, that governments are more proactively regulating the internet. And in some countries, there's a move towards what is sometimes known as digital sovereignty or cyber sovereignty or data sovereignty. So this is not the interface we are seeing between trade and the internet world. And what we see now, this is a relatively new area of research, but if you go back to the history of internet governance, even in 2005, the internet governance community had actually recognized that someday in the future, organizations such as WTO will play a very important role in this field. Next slide, please. Now, in this slide, I just wanted to highlight some of the synergies between international trade law and internet governance. But before I do that, I wanted to just again re-emphasize the fact that in a digital economy, so many businesses are now data driven. So if there are countries that impose regulations that restrict cross-border data flows through the internet, then that will definitely have an adverse impact on digital trade. But it is good to have the big picture in mind. When you think of data flows, it's not just government regulation, right? There are many reasons why data may not flow, or there can be hindrances to the free flow of data. There could be technological failures. What if my video suddenly freezes? That would be a technological failure. Then there are companies which have policies that limit certain kinds of content or data to flow. They are often known as geo-blocking policies. And finally, of course, I said that governments can regulate data also. Similarly, we can see the impact of these data restrictive measures in different forms. Sometimes they affect the architecture of the internet, so how different layers of the internet work with each other, or what the protocols are for data transfers might be affected. But the other impact, and something that we see more and more these days as governments try to regulate social media, is that companies themselves, what technology they use, what are their data collection policies, what are their business models, that is also affected. So companies, in order to comply with law, may need to modify these business and technological models from country to country. So there's a widespread impact. Now, what are the reasons why countries restrict data? Again, there could be many, and many of them are very legitimate reasons. Countries have public policies, there could be censorship related policy, privacy concerns, cybersecurity concerns, other kinds of regulatory concerns, security concerns. But there are also often protectionist reasons where governments want to protect their own domestic sector. Of course, the protectionist rationale is not easily admitted as the other legitimate policy rationales. Now, what I have found from my research over the years is that if you want to find this balance between these different objectives, essentially the exercise is balancing internet openness, that is a free and open internet, with cybersecurity and privacy. That's what can result in a stable and open internet that allows for the digital economy to grow. If I put it very simply, free flow of data will not happen in isolation. You have to facilitate internet privacy and security in order to enable this global digital economy. And you will not be perhaps surprised that trade agreements have traditionally not dealt with many of these issues, because a lot of trade agreements like WTO law belong to a very with these principles of internet openness, privacy, security. We create more opportunities for global economic welfare. The second thing is that we can use more and more of these technical inputs to also apply and interpret trade law, and I'll give you some examples. And finally, it's about getting new rules for the digital age. Again, it is so important to take these broader perspectives into account to figure out what are the gaps in WTO law or other trade agreements, and how can we have a more balanced digital ecosystem. Okay, this slide on trade privacy, and as I said, I'll explain with two examples, trade and privacy and trade and cybersecurity, and they're kind of similar, but they are definitely connected, but still distinct aspects of regulation of data. Now, most of you would know different countries have different kinds of privacy laws. I'll not go into many details, but it's helpful to know that when countries have different data protection laws, businesses, when they have to operate in these different countries, they have to change their business models, their data collection practices, their terms of service, so that they can operate in different jurisdictions. Now, some countries would have very strong territorial leanings, which essentially means that personal data is usually required to be stored within their borders, or there are many requirements if you want to transfer personal data abroad. of course, some of these requirements can be expensive for companies to implement, and especially for small and medium-sized enterprises, not so much for Google and Facebook, but more for the smaller companies. The other thing, so when you think about this diversity in the data protection model, obviously we know this can be a barrier to digital trade, because foreign companies may have to deal with so many different data protection laws across different countries. But at the same time, and this was clearly set out in the agenda when the session was introduced, privacy and data protection are really important. In a way, you can say if there is no privacy, we cannot have trust in digital trade. So it is very important. Now, within the WTO law, there are no privacy rules as such. I already told you that, but there are some exceptions. For instance, under the General Agreement on Trade and Services, or what is known as the GATS, there is an exception which allows countries to impose measures which are necessary to protect individual privacy. There are also some provision in GATS under the Telecom and Financial Services Annex which recognize privacy requirements. The bottom line is that countries can impose privacy measures as long as they meet certain standards. So they are not unduly trade restrictive, and they are necessary to achieve that particular objective. And there is quite a sophisticated legal analysis that you need to do under WTO law to see if they have met that necessity standard or not. Now, I told you in FTAs recently there has been a shift. So, for instance, the US-Mexico-Canada agreement, and in this part of the world, the CPTPP, and even to some extent the RCP, not RCP, RCEP, Regional Comprehensive and Economic Partnership Agreement, all of them have started adopting these rules, which require all members of the trade agreement to adopt some minimum data protection framework. I'll not go into details, but note that the language is not identical in all these FTAs. So for instance, US-led FTAs have very different language from EU FTAs, but there is a recognition that privacy is very central to digital trade. Now, I have already mentioned that privacy laws can sometimes implicate trade obligations. I'll not go into details, but it can violate principles of non-discrimination or certain domestic regulation requirement, market access requirements. So the question of how they can be justified under exceptions is very important. Now, I think there are two. So I said under the exceptions, there is this complicated legal analysis, and we don't need to go into details, but it's good to know at a high level that there is a weighing and balancing test that a WTO panel would do to examine the necessity of a particularly restrictive measure, privacy measure that restricts trade in some form. Now, there are two problems that might arise. One is to actually know whether a particular measure contributes to privacy protection. What kind of evidence? Should we look at technological evidence? Can we look at legal evidence? What do you do when there is no unanimity between countries as to what the correct privacy standard is? Because different countries have different privacy laws. The other problem is knowing what are the less trade restrictive alternatives available. So what if I say data localization is not the best alternative? The best alternative is to have some kind of a approval mechanism to transfer personal data abroad. Again, there can be very different policy priorities between countries, which makes it very difficult to know what the right solutions are. And another thing to remark here is that there is so much development in digital technologies that there are also many technological solutions that are coming up that can complement policy, but we still don't know what the future will be like. So the final point that I would like to make here is that, yes, when we think of trade and privacy, trade law does have a role. It can help eliminate disguise measures. So for instance, if a country is trying to protect its domestic sector, but trying to do it under the cover of a data protection law, a sophisticated analysis will reveal that no, there is a protectionist intent behind it. So there is a possibility there. Similarly, WTO panels have the possibility of looking at multi-stakeholder transnational privacy standards, which are evolving, and they can rely on expert evidence, but there are limitations because we don't have international consensus on many of these issues. Next slide, please. Now, this slide is very similar, covers similar issue, but at a very high level, many of you would know about cybersecurity, is usually known as confidentiality, integrity, and availability of data. That's it's called the CIA triad. Now, in cybersecurity, there is a technological component to it for sure, but there is one interesting development in many parts of the world, including in many parts of Southeast Asia, where countries are seeing cybersecurity as being broader than just technological security. They have ideas of economic security and self-sufficiency, cyber offense, law enforcement, and even in some countries, like in Vietnam, for instance, ideas of cultural security are also included within their cybersecurity law. So there is an expanding domain. And similar to privacy, again, cybersecurity standards can sometimes be a trade enabler if different countries agree on open, competitive, market-based standards. But it can be a trade barrier, for instance, if countries impose domestic cybersecurity standards which are not compatible with global standards, or where there are ban on certain foreign technologies for security reasons, or there could be data localization provisions, which are very common again in many parts of the world. There have been all these initiatives for security reasons, such as creating a national cloud, or requiring companies to give access to source code to governments. Now, all these measures, there is a possibility of many of these measures violating international trade law, including WTO law. But do keep in mind that WTO law doesn't actually have cybersecurity specific disciplines. And even if you look at FTAs, which are more recent, although there is mention of cybersecurity, the provisions are at a very high level. There's no like binding obligation that really comes out of it. Now, similar to privacy, you can justify cybersecurity measures again under general and security exceptions. Now, general exceptions are generally all kinds of legitimate public policy purposes, while security exception deal with national security rationales. So when a country thinks there's a national security risk, it would be examined under the security exception. Now, there's a trend these days that many countries argue that, look, we are imposing all these restrictions on digital services because of security reasons. But in reality, if you look at the security exception in WTO law and in many other trade agreements, there is a limitation in the sense that it's not a self-judging exception unless, for instance, RCEP is an exception. But many, or you can say majority of them, they don't contain self-judging exceptions. And there is a test that you have to satisfy, and that's a very high threshold, and it only applies to very limited circumstances. For instance, when there's a war going on, or when there's some risk to your nuclear facilities or defense facilities. So although countries are having this making this broad argument that everything is justified under our cybersecurity laws because of national security reasons, that may not meet the test under international trade law. And that is a problem because it is politically sensitive and can create a lot of backlash within the system. And you can already see that, especially when you think of China and its interaction with US and within the WTO and outside. And similar to, again, privacy and security, I have similar kinds, privacy and trade, I have similar kinds of conclusions that, yes, to some extent, trade law is effective to weed out protectionist measures. When a data localization measure is said to be for cybersecurity reasons, but if you cannot show for any link between your cybersecurity measure and the practice of cybersecurity in your country, then that could be caught by the exception in trade law, in trade agreements. But the same limitation exists. How do we recognize private and multi-stakeholder standards? How much can the panel, what kind of liberty does the panel have? Or does the panel have to defer when WTO panels deal with, do they have to defer to national regulatory objectives? Again, that's unclear. And finally, just very, very briefly, I wanted to, in my last slide, just highlight that although there are all these deficiencies, next slide, please. Although there are all these deficiencies, we have mechanisms to move forward. So I've highlighted some of them. I'll not go through all, but I'm happy to take questions. One of them I want to highlight is that within trade agreements, despite all the limitations, we have principles that can help, principles on transparency, domestic regulation. There's a provision on mutual recognition agreements. There is a trade policy review mechanism at the WTO that all countries have to go through. This is another mechanism for us to have dialogues on this issue. We have discussions on how disciplines on data flows can be developed. It's happening at the WTO currently under the joint statement initiative, but also outside WTO. And there are many opportunities also for international regulatory cooperation. in this sector, not just between WTO members, but also between WTO and other international organizations who are dealing in this area. And I'll also like to emphasize the importance of experimentation in this area. There have been initiatives where private sector and governments have come together for cyberspace related policy problems, and they have been able to find solutions. So there's a host of options available for us to explore together as a global community. And that can help drive the agenda forward so that more and more countries can meaningfully participate in digital trade and global economy. Last slide, please. Yeah, so thank you so much. This is my email address. If anyone is interested or would like to discuss something, please feel free to email me. And thank you once again for so kindly inviting me. It has been an honor to speak to you.
Thank you very much, Ms. Mishra. Wow, big applause, I guess. Thank you very much for sharing, very interesting, and I really point out some very important point. But I will let Mr. Parikasit to continue the second presentation. So after that, he will deliver his presentations, and then we can sum up. Okay, of course, after Dayu. Okay, so now we will, I will introduce him, even I guess like more or less like maybe 50 or 60% of the participants already know you, but I think it's my job to introduce you again to all the participants. Would you please to share the curriculum vitae of Bapak Sigit? Okay, so while waiting, yes, that's him. So what I want to give more information, all the participants can read that Mr. Igusti Ngurah Parikesit Widya Teja SHM Hum LLM PhD. So I will give educational background of him. He started his Bachelor of Law at Faculty of Law, University of Brawijaya Malang, and then his Master of Law at the University of Brawijaya, also in 2004 until 2006. He continued his Master of Law in the University of Washington, Seattle, USA. So he got his LLM for Global Business Law. And then he just come back to the faculty. I also want to, would you please to give big applause also, welcoming him back at our faculty. After quite a years, he lived abroad to complete his PhD at the School of Law, the University of Melbourne, Australia. So I guess you can read the rest of he has a very quite long CV also, just like Ms. Mishra. But now the time I think is more important for him to deliver the presentations for this seminar. So Mr. Widya Teja, time is yours.
Thank you. Good morning, Om Swastiastu. Your Excellency, the Vice Dean of General Affairs and Human Resources, the Coordinator of Master of Notary Program, Faculty of Law, Udayana University, all professors, Honorable College, and the organizing committee, all distinguished participants, both online and on-site, and of course my friend Neha. As maybe some of you are not recognized that this seminar just reflect the power of women. Can you recognize from the beginning, the Vice Dean deliver the opening speech, the organizing committee, the moderators, and the speakers today? I wish I could give up the chair for the and also it is a pleasure to speak again here after 4 years in this special occasion with a special and interesting topic, in relation to regulation of data laws through international trade law. I'm so glad my friend Neha has presented important issue that might not be addressed properly, and only a few scholars have involved in this discourse before. Neha has captured that the digital economy trend in the current industry 4.0 and which will go to 5.0 soon. However, there was no regulation on data laws in the international level. Each country has set up its own standard or benchmark on internet openness, internet privacy, and internet security, and it will affect the existence of digital economy. My presentation will focus on how Indonesia has regulated the data laws and how it has supported the existence of digital trade. I will start by explaining the importance of the regulation of data law in international trade law perspective. Then I will show how the current Indonesian law and regulation have regulated data laws. Finally, I will analyze the implementation of data laws, identifying whether they are actually open, secure, and protect our privacy. In the next slide, to answer the first question, why we care about the issue of data laws? Could you guys imagine here what will happen if the data or internet that we have already used every day is not really open, is not really secure, and does not protect our privacy? Who will take an advantage from this situation? There was a good article written by John Napton in 2012 or 9 years ago. At that time, there was no TikTok. Instagram has just started. He said that internet governance or regulation was the same with the term to control. The next question is, who control the internet? The answer is nation state and giant corporation. They will basically dominate our world and shape its development. In the next slide, I will show you who are the giant corporations. I have a list, the top 20 biggest web property over time, and I believe almost all of you have familiar with. Do you believe if they may know your data privacy? Along with this giant corporation, some government, in the next slide, particularly the authoritarian one, are controlling their citizens. There are a bunch of examples as my following slide will show. We know what's happening in Russia, where the government is stepping up to continue campaigning controlling internet. In the next slide, the political issue was the major driver, as also explained, when the more government disrupt internet for political control. I have also shown the link of the source of those two articles, so you guys can check for further accuracy. And what happened in Indonesia in the next slide? Okay, I believe some of you already know this news. 2 months ago, when the webinar about the Wawasan Kebangsaan test for the employment of KPK, Corruption Eradication Commission, who do you think disrupt this event? Hopefully no one will disrupt this webinar. So, what is the connection with the digital trade? When they limit or take down the internet, they forgot one thing. If I'm an entrepreneur, rely my business on the online transaction, on online business, what will happen if the internet is not available or restricted? So the government need to think wisely and consistently. For example, in the pandemic era, as illustration, they don't want to impose lockdown. Why? Because of economic reason. However, they sometimes lock the internet down. Do they aware their impact on digital economy? When they are consistent and the primary goal is to promote economic growth, don't do lockdown, don't limit the internet, or if they did, they have to make sure that the restriction or limitation doesn't harm the digital trade. Never think that only a few entrepreneurs in Indonesia have involved in digital trade, because that's very old school perspective. As an ideal solution, of course, it's required, as Neha said, the presence of international trade law that adopt the principle of internet openness, privacy, security as a means of supporting digital trade. In the next slide, I will refer about how Indonesia has regulated data laws and do they address the existence of digital trade. IC Law number 11, 2008, or famously known as ITE Law, as my starting point. In brief, at least on paper, this law has mentioned about the importance of digital trade. The consideration clearly explain the utilization of information technology that has important role in national trade and economic growth. Some terms have been introduced, such as electronic document, electronic certificate, electronic signature, electronic contract, and domain name. In the next slide, this law also explains that electronic information and document are valid legal evidence. Article 18 then underlined that electronic transactions that are stated in electronic contract shall bind all parties. The principle of private international law will be applied if parties don't make a choice of law. In the next slide, Article 23 explains that any administrator, person, business, entity, and society shall be entitled to hold domain name on first applicable principle basis. So from this law, everyone can have like a private or online domain, free to have domain, free to buy hosting domain and minutes in relation to business activities. In the next slide, in the relation to internet privacy and security, this law has explained what constitutes prohibited act, including the following reason: accessing computer and electronic system of other person in any manner whatsoever, and carry out interception or wiretapping of electronic information in certain computer of other person. I know some scholars have expressed their opposing argument in relation to what they have called as rubber article in this law. So there are many controversial prosecution for people who disagree with the government policy. However, concerning digital trade, this law is pretty good, at least on paper. In the next slide, as we all know that following the hierarchy of law, this law requires governmental regulation to be applicable. Unfortunately, when the ITE law has addressed the issue of digital trade, the following two regulations seem to neglect the digital trade and put priority on the controlling the internet. For example, in the government regulation number 82 of 2012, it states that minister has the authority to supervise the electronic system operation, including monitoring, control, inspection, search, and security. Article 82 then explained that supervision on the domain name operation is undertaken by the minister. In the next slide, replacing this regulation, the government issued Government Regulation Number 71 of 2019. In relation to internet privacy, this regulation has addressed the importance of internet privacy with the regulation of the protection of data. Personal data may only be collected on a restrictive, specific, and lawful basis with the knowledge and consent of the data subject. In the next slide, this law has also regulated right to be forgotten or right to delisting or right to reassure. Article 15 requires that electronic service operator or ESO to delete electronic information and electronic document that is within its control, which is no longer relevant. So, in terms of internet privacy, this regulation is pretty good. In the next slide, however, the spirit of controlling the internet has increased too in this regulation. According to Article 6, state sector ESOs and private ESOs are required to register with the minister prior to their electronic system being made accessible to user. In the next slide, article provides that the government is authorized to prevent dissemination and the use of electronic information by means of blocking of access and give instruction to an ESO to block the access if, among other things, they violate the provision of the law and regulation, causes public disquiet, and disturb public order. So you can see in my presentation the elucidation of this provision. Next slide. After explaining the existing regulation, it's my turn to briefly analyze the implementation of this regulation. To be fair, I haven't conducted any research and publication yet on this issue, so I just rely on other data. And according to Freedom House, for example, we are in the position of partly free. Almost in every parameter, we have moderate scores. Next. I will show how some example why the survey has put Indonesia as a partly free or partly restrictive in terms of internet governance. You guys might still remember that hundreds of thousands of websites containing what the government deemed quote-unquote negative content continue to be blocked. Disinformation and manipulated content was a problem in the April election. Both presidential candidates, as we remember, reportedly hired online campaign strategy who mobilized paid commenter known as buzzer and automated account to spread political propaganda. In July 2018, there was a case when the journalist in Kemajuan Rakyat died in detention while awaiting trial on charge related to the reporting a land dispute between farmer and a farm in oil company. What makes more disappointing is that the fact that the revision of ITE law has been postponed and it was excluded from National Legislation Program 2021. In the next slide. So, what is the impact for digital trade? The problem that I like to discuss with all of you guys here is about whenever the government imposes data or internet restriction, it will harm the digital trade as the following slide will show. As I said earlier, the government needs to establish detailed rules, filtering more cases content, minimizing the adverse impact on digital economy. In the future, as Neha also has addresses, that international trade law that combine the principle of internet security, openness, and privacy are crucial to support international trade. I think that's all my presentation for today. Thanks for the opportunity.
Okay, thank you very much. Would you please to give big applause to Mr. Parikesit Widyateja. Now, I will continue with a presentation from Ida Ayu Agung Saraswati. She is a student of the Master of Notariat Faculty of Law, Udayana University. Would you please to show the CV of her? Okay, so I also will give a brief information that she is graduated from the Faculty of Law, Diana University in 2019, so just like 2 years ago, and now she still study at Master of Notary program. So I can give slightly the organization's experience of her, that she joined the Asian Law Students Association, ALSA. So, and she also joined several activities at the Faculty of Law students organizations. Okay, so Ida Ayu Agung Saraswati will deliver the presentation. The title is Protections of Personal Data in Cyber Notary. So, Dayu, time is yours. You have 20 minutes.
Okay, thank you so much. Om Swastiastu. Assalamualaikum warahmatullahi wabarakatuh. Shalom Nama Budaya. Good morning, ladies and gentlemen. My name is Diselenggarakan Saraswati. Thank you so much for choosing me as the representative of my friend in Notariat Study Program, Faculty of Law, Udayana University. And now we would like to have a presentations regarding protections of personal data in cyber notary. So the regulation related to the duties and the authorities of notaries in Indonesia are regulated in Law Number 2 of 2014, concerning amendments of Law Number 30 of 2004 concerning notary positions. Based on the provisions of Article 1 Number 1 stipulates that notary are public officials who are authorized to make authentic deeds and have other authorities as referred to in this law or based on other law. Regarding the authority of a notary, it is regulated in the provisions of Article 15, and the authority of the notary is explicitly regulated in the provisions of Article 15, paragraph 1, which stipulates that the notary has the authority to make authentic deeds regarding all actions, agreements, stipulations required by laws and regulations. Invitations and or decided by interested parties to be stated in the authentic deeds, granting the certainty of the date of making the deed, keeping the deeds, providing grocer, copies, quotations of the deed, in this case as long as making of the deed is not excluded or assigned to other officials or other persons who stipulated by law, as well as other authorities regulated in paragraphs 2 and 3. And the other authorities of the notary, which are regulated implicitly in the provisions of Article 15, paragraph 3, which stipulates that a notary has other authorities regulated in the legislation. And in the provisions of the explanations of Article 15, paragraph 3, it is clearly explained that what is meant by other authority by notary is the authority of to certify electronic transactions, or cyber notary, make a deed of work pledge and or craft mortgages. So based on these provisions, Law Number 2 of 2014 concerning the position of notary has begun to open a gap to the regulations of cyber notary. But regarding cyber notary itself, there is no more comprehensive regulations regarding the authenticity, procedures, and also the mechanism. Meanwhile, Edmond Makarim argues that cyber notary is related to notaries who carry out their duties and authorities based on information technology, especially concerning to making authentic deeds, certifying electronic transactions. Okay, next slide. Okay, regarding the definitions of the phrase certifications, according to Emanuel's opinion, certification is a procedure whereby a third party provides a written guarantee that a product, process, or service has met certain standards based on an audit carried out with an agreed procedure. The law and regulations do not stipulate the definitions of certifications, but in the government regulation number 71 of 2019 concerning the implementations of electronic system and transaction, it does stipulates what the certification is. And furthermore, the provision of Article 1, Paragraph 2 of Electronic Information and Transactions Law stipulates the definitions of electronic transactions. And the meaning of certifying transactions that is done electronically regarding those regulations is the procedure whereby the electronic certifications operator provides a guarantee that illegal actions carried out using a computer network and or other electronics media has met certain standard provisions based on an audit carried out with an agreed procedure. So in certifying electronic transaction, a notary has the authority to act as a certification authority, or trusted third party, so that a notary can issue a product in the form of digital certificate to interested parties. Cyber notary has the main functions in conducting certification and the authentications of electronic transactions activities. Next slide. Okay, the purpose of holding electronic transactions certification is to guarantee certainty, order, and legal protections for the community in technological progress and the need for authenticity evidence regarding act, agreements, stipulations, and legal events made before or by authorized officials. The role of a notary in the electronic transactions certification process is more clearly regulated in the provisions of Article 27 of the regulations of the Minister of Communications and Information Technology, number 11 of 2019, concerning the implementations of electronic certifications, which state that the application submitted by the applicant in the case of issuing electronic certificates to the electronic certification operator may A. carry out the inspection themselves, B. appoint a registration authority to carry out inspections, and or C. appoint a notary as the registration authority. The authority of a notary in this article is to be appointed as a registration authority, which is the authority of the delegations from the provider of electronic transaction certifications, because the notary has the responsibility for the completeness of the requirements submitted by the certificate applicant. As a registration authority, it is a duty for a notary to carry out these checks in the form of verifying the correctness of identity and checking the completeness of documents. The electronic transaction certification process at least consists of procedures for granting and acknowledgements of electronic certifications operator, procedures for having electronic certificates, supervisions of electronic certification implementations, and operations of the main electronic certification operator facilities. Next slide. Okay. However, Article 5, the previous slide. Okay. The previous slide. Okay. However, Article 5, Paragraph 4 of Law Number 19 of 2016 concerning amendments to Law Number 11 of 2008 concerning electronic information and transactions states that the provisions regarding electronic informations and or electronic documents do not apply to letters which, according to the law, must be made in written form. And also the letters And also the letter and its document who must be made in the form of notarial deed or a deed who made by the land titles registrar. Okay, the next slide. Okay. Cyber notary actually provides an opportunity for notaries to have the authority to store documents in the form of electronic documents. Storing documents in the form of electronic document has many advantages, including reducing paper usage and taking up less space, so that is pretty economical, efficient, and effective. However, the negative impact of electronic document storage is the possibility of parties taking advantage of electronic stored documents or cybercrime, which can harm parties who use the services of the notary in exercising their authority in cyber notary. So that is important to protecting personal data in terms of cyber notary. Okay, in the provisions of Article 16, letter F of Law number 2 of 2014 concerning notary positions, it stipulates that notary is obliged to keep everything about the deed that he made confidential. And all the information that's obtained for the making of the deed in accordance with the oath or promise of office, except as otherwise determined by law. So it is an obligation for the notary to keep everything about the deed that he made confidential. And the provisions of this article are reflections of the very importance of protecting the data of the parties to ensure the legal protections to the parties in the deed. The most basic legal aspect related to the protections of personal data in Indonesia are contained in the Indonesian constitutions of the 1945 constitutions, namely in the provisions of Article 28, letter C, paragraph 1, and Article 28D. And in the 1945 constitutions, the regulations regarding personal data implicitly can be found in the provisions of Article 28F. And the regulation regarding protections personal data is contained in the provisions of Article 28C, and the provisions regarding the freedom to store information and the protections of data and information attached to it are contained in the provisions of Article 28C, paragraph 1 of the 1945 Constitution. However, in Indonesia, the law that specifically regulates personal data protections does not yet exist, but the aspect of its protections has been reflected in other laws and regulations. Next slide. The following, there are some of the laws and regulations in Indonesia that have regulations regarding the protections of personal data. So there are law number 39 of 1999 on human rights, which regulate in Article 15, paragraph 2 and Article 32. And then we have law number 23 of 2006 concerning populations administration, which has been amended by law number 24 of 2013 concerning amendments to law number 23 of 2006 concerning administration, which regulate in Article 84, 85, 86, paragraph 1. And then next we have law number 19 of 2016 concerning information of electronic transactions, which has been amended by law number 11 of 2008 concerning information and electronic transactions in Article 26, paragraph 1. And next we have law number 36 of 1999 concerning telecommunications in Article 22. And then next we have government regulations number 82 of 2012 concerning the implementations of electronic system and transactions in Article 12, paragraph 1, letter C, Article 22, paragraph 1, Article 38, paragraph 2, Article 39, paragraph 1, Article 55, paragraph 3, and also Article 68, paragraph 1. in the regulation of the Minister of Communications and Informations of the Republic of Indonesia, number 20 of 2016, concerning protections of personal data in electronic system, in Article 2, Paragraph 1, and Article 2, Paragraph 3. So we can take one example in law number 19 of 2016 concerning information and electronic transaction, which has been amended by law number 11 of 2008 concerning information and electronic transaction in Article 26, which stated that the use of any private information and data through electronic media that is carried out without the consent of the data owner is a violation of privacy rights. The approval as referred to in this law is not only about the yes or no statement in the single click or double click command, but must also be based on a person's awareness in giving consent to the use of utilizations of personal data in accordance with purposes or interest conveyed at the time of data acquisition. Protection of personal data in electronic system based on this law includes protections from unauthorized use, protection of electronic system operators, PSE, and protection from illegal access and interventions. Next. Okay, in the following, we have the comparison of personal data settings in other states. First, we have European Union General Data Protections Regulations, and then next we have United Kingdom Data Protections Act 1998, United States US Privacy Act 1974, Hong Kong Personal Data Privacy Ordinance 1995, Malaysia, the Personal Data Protections Act number 709 of 2010, Singapore, Personal Data Protections Act 2012, South Korea, Personal Information Protections or PIPA 2011, and last but not least, we have Japan, Data Protections Act. And then there are some general principles regarding data protections. The United States and the European Union, they have the same principles, which are notice principle or awareness principle. So consumers must notify the personal data that will be accessed by the second party. And then we have the choice or consent principle. So the consumers have the right to choose whether or not their personal information is accessed, which this process is carried out by clicking on the option accept or decline that appears on the website when in an online position. And then next we have access or participation principle. So the consumer have an active role in this principle, and namely the right to the access information about themselves to any party and the right to collect their personal information. And next we have data integrity or security principle. So the access must be precise and secure. To ensure this, you must always recheck and always contact the first party, and in terms of security, the second party must have technical mastery of how to secure the data, including the filtering process, so that the data that has been collected cannot be penetrated by the irresponsible party. And then the last but not least, we have the enforcement or the redress principle. So the principle cannot be effectively enforced if there is no mechanism for law enforcement. Okay, now in Indonesia, the laws and regulations draft concerning the protection of personal data, as we know, is still at the preparation stage. And this preparation depends on the Ministry of Communications and Information. So now the protections of personal data is regulated by 32 laws and several other derivative regulations. As a result, the implementation and supervisions of this issue are spread across variety ministry or agencies. For example, the misuse of personal data in e-commerce is at least regulated by at least regulated by the telecommunications law, the information and electronic transactions law, the consumer protections law, and the trade law. So indirectly, the protections of personal data is under the authority of the Ministry of Trade, the Ministry of Communication and Information. Without strong coordinations from the ministry, the implementations and supervisions of consumer protection will be difficult to ensure. Based on this explanation, the protections of personal data is important for special or comprehensive regulations to be made. One of which is to support the provide legal certainty for cyber notary practices in Indonesia and provide legal protections to parties who use notary legal services, especially in personal data protections. So that's our presentations. We are really sorry if there are lots of shortcomings, and please give up the inputs for the better. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom Namo Buddhaya, and thank you so much.
Thank you very much. So, would you please to give big applause once again to all the speakers? After the first sessions, we will continue with the second sessions that we have the discussion. We have the participants offline, and of course the participants online is like almost 300, over 300 persons, if I'm not mistaken, informed by the committee. So for the first term, I will open an opportunity for the participants who join us online. Do we have, yes, I guess we have question from Ms. Eva Laheri. Is it possible to connect her with us here so she can directly deliver the question to the speakers? Ms. Eva Laheri, can you hear me?
Hello, you can hear me?
Yes, we can hear you clearly.
Okay, thank you. First of all, pardon of my casualty because up to now I'm on the site inspection, so I cannot connect through laptop, but only through cell phone. So might be if my voice is missing, just let me know first.
No problem.
Thank you. First of all, thank you to all the speakers for sharing the very important issue in this section. And I would like to ask all the speakers in generally about their opinion. So it might be a practical question, but in my point of view, it is very, very important to know the opinion of the expertise in this situation. So related to the data law, I think and I believe that the data security is the major concern or major issue that affects to the stability of the international trade as well. And then it's not just about how the government regulates everything. And I think in the event of the damage is the most important issue to sort out. So particularly, my question is how we address a claim in order if there is a data leaking. So either we require to claim to the parties who involved or to the government as a service provider or another public service provider, or to the notary as a certification authority. So I need to understand more about how the legal impact will address to each party in order to the in case if there is a damage in future, because I believe the damages is the most issue we need to protect in the data law.
Okay. Do you have any other questions or?
No,
That's only. Okay, thank you very much, Ms. Laheri. For the first term, I will open around 3 questions. So, do you have any other participants to? Okay, I see Professor Darmawan raising hand. She is our professor in the private law. So it's a pleasure. If you have any question, Professor, time is yours.
Thank you, Bu Ayu. First, I would like to appreciate the speaker. So it is really open our mind, especially in the topic of data protection. The first question I would like to ask Bapak Barikesit, and this is maybe also just sharing. The first one about the act number I'm sorry, I forget. Because Dayu already mentioned, we have the amendment of the law is concerning the law number 19 2016. I would like just to inform the law number 8 of 2011. If, for example, you would like to see another amendment, you may see in the law number 19 2016. That's the first one. And then the second one, this is my perspective. When we see how the internet go around in international trade law, according to me, also important to see from the agreement, from the contract perspective. For example, you mentioned that the giant corporation have really more power. Who is the giant corporation? According to me, one of them is internet service provider. So when we still don't have the law to regulate how the internet can be help us in international trade or in business, we also can use the contract ways, the contract model. For example, between the businessman or even we are our academician, something like today, when we have event something like today, if, for example, the internet down, who take responsible? One of them is, according to me, is the internet service provider. So why we not use also to build the law through contract arrangement or agreement? This is my opinion. And then the second, I would like to comment to Dayu. So Dayu, I'm proud about you. You speak clearly about the cyber notary in Indonesia, and then also you also present really a lot about international trade, data protection. But for me, so this is look like jumping, yeah. Go from the cyber notary, and then finally you talk wider about the data protection. So I cannot see the relation between them. However, this is nice. So only one question for you, because we know that we have the cyber notary, and then whether the electronic certificate can use for example, if we have a transaction between sell and buying land in Indonesia, is it according to you, is it suitable using cyber notary, or we using internet certificate, electronic certificate? Just one question for you, and then maybe you can find the article to support your argument. Thank you.
Thank you, Okay, thank you very much. Thank you very much, Professor Darmawan. So we have here also, So we have here also Ibu Dr. Dewi Sulistianingsih. That's it. Raise question for Miss Neha. Miss Mishra, can you read the questions or is it short? Yeah, so you can directly read the questions. Okay, so I guess for the first term, I will give these three participants to deliver the questions. We can continue to the other terms of discussion. So I will give the time to all the speakers to answer the questions or deliver any comments. Maybe the first opportunity I will give to Ms. Misra.
Okay, thank you so much.
Please.
Okay, you put me up first for the trial. Okay, to answer your question, Miss Devi, Miss Devi's question is if I can share my perspective on data laws in Australia and India and what might be what Indonesia might be able to adopt. Very broadly speaking, now because data regulation can encompass many different areas, let me just talk from a data protection or privacy perspective. Now in Australia, they have a data protection law. The fundamental approach in Australia is that of what is known as an accountability based approach, which essentially means that look, these are the high level principles of data protection in our country. Every company that operates in Australia has the obligation to ensure that they are using data, personal data, in a manner that complies with those data protection principles. So this is different from a prescriptive approach, like the European Union, which has the general data protection regulation, where the government rather than being an accountability based approach, the government says, well, you can transfer personal data to this country, you cannot transfer to that country. So it is much more regulated. Here it is the obligation of the company to comply with the data protection laws in Australia. In India at the moment, like Indonesia, India is also developing their data protection law. The approach is quite different, very similar to the European Union in some respects, in the sense that Indian government wants to regulate where personal data can be transferred. There are also a lot of requirements regarding transfer and processing of personal data. But there have been some concerns raised about the data protection bill in India. One of them is that there are certain elements of data localization, which many people are worried will affect the domestic digital sector, especially small size companies. And the other major worry is that there's a lot of discretion provided to the government to exempt government agencies from those privacy laws. On security grounds, on some other grounds, which can also be exploited in some cases for government surveillance. Now, as regards how this might be relevant to Indonesia, it's a hard question for me to answer, but this is what I would like to say. It's important that every country adapt and develop their data protection law based on their local conditions, what their local digital economy requires, and also their regulatory capacity. So what the European Union can do under the GDPR may not be possible for Indonesia or India to do, because we don't have that kind of regulatory experience. So when adopting a data protection law, I would say it's good to think of your own personal conditions, but also think about the bigger digital economy, how Indonesia might want to avoid laws that will prevent Indonesian companies from doing businesses abroad and from foreign companies to deliver good digital services and digital products to Indonesia. So that would be my answer. To Miss Eva, I have a brief comment, just a brief comment. She mentioned a lot about data leakage and data breaches. So one thing is lot of countries have data breach notification requirements. So if there's a data breach, then the companies are under an obligation to inform the government and also the consumers in some countries, depending on how big the data breach is. And there are also some possibilities in that sector. For instance, there could be coordination among cybersecurity authorities and agencies of different countries. There is some discussion in this regard, but there hasn't been any. There's no internet. There is one convention on cybercrime, but there is not that much of coordinated action. The other development in many developed countries, say in the EU and US and some other jurisdiction, is that so the government is often coordinating with the private sector in development of cybersecurity standards and best practices. So such kind of cybersecurity strategies could also be a way of the future for countries like Indonesia as well. Okay, thank you so much.
Thank you very much, Ms. Misra. Do you have any further questions, Ms. Laheri or Ibu Dr. Dewi? Is that clear enough?
Thank you. Okay, it's clearly.
Okay, thank you. And I will give the opportunity to Mr. Wijateja to address the issue that by Ms. Lahiri, and also maybe you can give any comments from the statement of Professor Dermawan. Thank you.
Thank you for the opportunity. For Ms. Eva Laheri and Ibu Supasti, Ibu Professor Supasti, thanks for your question. I would like to give some brief comment. When we talk about internet governance, it should consist at least three principles: internet security, internet privacy, and internet openness. When the seminar and Neha also explained that the international trade law could be a starting point to regulate the internet governance internationally, I pretty bit optimistic that it could be happen in the near future. You guys can imagine what was happened when the WTO had not existed yet. Life before WTO is life with a lot of protectionism, with a lot of tariff barriers and non-tariff barriers. After the WTO established, they uphold the discriminatory and the free trade regulation. Then we know international trade law, as we know all know. In terms of internet governance, maybe the the entrepreneur who rely on online business can provide a real example how restrictive of the data in particular countries. If I am the entrepreneur, let's say I have a coffee product, Banyuwantis coffee, and I want to sell, I want to penetrate, I want to operate in the China territory. Do they give me access? So what happens if the China company want to sell their product here in Indonesian territory? Why they can sell here, but we can't sell over there in China? Because of the different standard of internet openness. How to solve this situation? Of course, we need agreement internationally to make sure to realize that international trade should be open, internet governance should be open too, and every digital trade, regardless their origin, can compete freely and non-discriminatory. That's the philosophical basis why we need to regulate internet governance in international level, and the international trade law could be the starting point. And of course, when the international standard has been established, they will explain further about the internet security, internet protection, and privacy, and then Indonesia and other WTO member can apply in national level. For the second question, thank you so much, Ibu Professor Supasti, for adding some important information. And I agree if the internet service provider should take responsibility, and maybe it is my spontaneous perspective. When there is a contract agreement, it could be when something happened in the internet connection and the object is our contract is so rely on the internet, we can put or we can classify force majeure, force majeure, interpret extensively and put internet down as a force majeure situation. Maybe it depends. Of course, it depends on how the significance of our business rely on the internet. I think that's all my comment.
Okay, thank you very much. I will give time to Dayu. Maybe you can address what question by Ibu Ms. Laheri and also Professor Supasti Darmawan.
Okay, thank you so much. Regarding the questions of Mrs. Eva Laheri. Okay, as we know that the provisions of Article 16, letter F of Law Number 2 of 2014 concerning amendments of Law Number 30 of 2004 concerning the position of notary, it stipulates that notary is obliged to keep everything about the deed that he made confidential. And all the information that's obtained for the making of the deeds in accordance with the oath or promise of office, except as otherwise determined by law. So it is an obligation, yeah. So there is clearly said that is an obligation for a notary to keep everything about the deed that he made confidential, and the provisions of this article are reflections of the very importance of protecting the data of the parties to ensure the legal protections of the parties in the deed. And if there is any leakage in the personal data, of course, the notary have to responsible regarding of that things happen, especially for the negligence or the mistakes aspect of the notary. So first of all, the responsibility that notary can get because of the leakage of the personal data is first we have the responsibility of the civil basis. And then the second, we have the administrative responsibility, like the verbal warning, written warning, temporary suspend, dismissal with respect, and disrespectful dismissal. And also the code of ethics responsibility. Yeah, the sanctions in this code of ethics of the notary is regulated in Article 6. That stated the sanctions are that imposed to the members that violate the code of ethics can be in form of the verbal warnings, coercing from the association membership, unsetting or dismissal from association membership, and dishonorable dismissal from the association membership. Okay, that's all for the question from Ibu Eva Laheri. Okay, next, for the questions from Professor Supasti Darmawan, this is my lecturer. Thanks so much for the questions. Actually, based on the regulations of the Minister of Communication and Information Technology number 11 of 2008 concerning the implementations of electronic certifications in Article 26, paragraph 1, Electronic certificates function as an authentic and verifications tool for, first, the identity of the electronic certificate owner, and B, the integrity and authenticity of electronic informations. Based on that Article 26, Paragraph 1, as we know in the elucidations or the explanations of Article 15, Paragraph 3, that stipulates that a notary have the authority to certify the transactions, electronic transactions. Of course, the certificate of the electronic certificate can doing for the transactions, of course, like the land for the leasing maybe, or the land if we want to buy the land or something like that, it can be applied, something like that. Thank you so much for the questions. We are sorry if there's a lot of shortcomings, and that's all. Thank you.
Okay, thank you. That's the first term for the discussion sessions. I will open the second session for the discussions. I will give the opportunity for participants who are here. Okay, I see Mr. Satya Yuda Dananjaya, PhD, and then one student from the Master of Notary. Okay, so we will start with two questions first. Please mention names and also who are the speaker that you want to address the question. Thank you.
Thank you so much, moderators. To address my question to Miss Neha, PhD. So first of all, I would like to say thank you so much for your great presentation. So I got a lot of valuable information with your presentation. So I have a question regarding data protection rules. So I concern with your fifth presentation slide. So general knowledge that describe the concern of data protection exists wherever personal data is collected or stored. So at present, there is no laws that specifically regulates data protection in Indonesia in a comprehensive manner. So I underline in a comprehensive manner. So the provision applicable for data protection in Indonesia are found in several regulations, like all speakers mentioned in their presentation. So my question is, according to your perspective, what if, for example, my company or organizations fails to comply with the data protection rules? So how to solve it if we connect it with the rules in WTO and free trade agreements? Thank you.
Is it quite clear, Ms. Misra? Or yes, okay. You can continue, Mr. Dan.
Oh, that's all my questions.
Okay, you
Only one question. So according to your perspective, what if, for example, my company or my organization fails to comply with the data protection rules, and how to solve it if we connect it with the rules in WTO or in free trade agreement? Thank you.
Thank you very much, Mr. Dananjaya. And then the second question, yes, please. Please mention your name.
Hi, my name is Ishans. I would like to give a question to Mrs. Neha. Hi, good day, Mrs. Neha. Nice to meet you. I have a question. When you're talking about rolling our various frameworks, you touch on in the documents that in Indonesia is under civil law and versus between Australia such an common law. Is it for you? How can it be more? How can it be more difficult? And I wonder in Indonesia is have a notary is very important, and I know in Australia having a notary also. But my question is, um, why in Australia notary is not unnecessary for the people in over there, and how to about the regulation regulated to the cyber notary put it in Indonesia. Thank you.
Thank you for the question. Okay, so it's all for Ms. Mishra. So I give the time for you to respond it. Time
Thank
short.
Yes, thank you so much. Okay, I'll try to answer based on whatever I know, but I apologize in advance if my answers are not good enough. So the first question was if there's a company or an organization in India, which in Indonesia, which fails to comply with data protection laws, then what are the potential implications from a WTO law context? Now, normally speaking, WTO law does not govern individual companies. So, if an individual, especially say when we think of if your company is providing some kind of service where you're using data and you're not for some reason you have not been able to comply with domestic laws, that would normally not be an issue that WTO law would deal with. Of course, you would still have liabilities under the domestic laws in Indonesia. So whatever regulations exist, and I do note you said there is no omnibus legal framework. There are different regulatory frameworks which deal with certain aspects of data protection. But one thing to note is that how free trade agreements could help in this regard, or how WTO law in the future could help in this regard. So one of the trend that has been observed in some free trade agreements is that all the partners who come together and negotiate a trade agreement agree that they will adopt a certain baseline framework on data protection. Now, the provision often varies. In some agreements where trading partners see eye to eye, they have similar regulatory frameworks or similar mindset, they actually choose a particular international framework. So one example is the US Mexico Canada agreement, where parties have agreed that we will look at the OECD guidelines as a framework for data protection. But there are other regional agreements where that agree. So, for instance, the Comprehensive and Progressive Trans-Pacific Partnership Agreement or the Regional Comprehensive Economic Partnership Agreement, these agreements don't really prescribe a specific standard. What they say is that every member has to adopt a data protection law consistent with international standards. Now, the problem is if there is no international or a consensus that this is the international standard, then pretty much every country has the autonomy. They can do whatever they want, and they can argue that there is no international standard, so we have no obligation. So that's what happens. So if Indonesia were to join many of these free trade agreements and adopt a basic framework, then the advantage that you could have as a company is that when you design something, your data collection practices would be similar to all the other countries with which Indonesia had signed a trade agreement. So you wouldn't have to change your business model from country to country. You could have a similar business model that could work across different countries. So that would reduce your cost, especially if you're a SME, it is a big advantage. But having said all of this, ultimately, WTO law does not really punish individual companies for violating data protection laws. You can still be liable under your domestic law, but not under WTO law. As far as the second question is concerned, unfortunately, I'm not an expert on cyber notary and I have limited knowledge. But at a high level, I'll try to answer the question. So the question was that, if two countries have different legal frameworks, one say a civil law system and the other a common law system, then how can you coordinate it at an international level? So to that, I can answer this way that yes, it's very difficult for different countries to have the same framework, especially if one comes from a common law system and one comes from a civil law system. But there are some solutions under WTO law. One of them is mutual recognition agreement. So you recognize each other's practices without actually harmonizing laws. So that is one prospect. The other prospect could be just regulatory cooperation in the relevant regulatory organizations, and doesn't have to be WTO. There are certain areas where WTO is not the expert body. So that could be another possibility. But unfortunately, I do not have sufficient knowledge why notary system is not that important in Australia. So I'm very sorry, I'm unable to answer that question. Thank you so much.
Thank you very much. Is that quite clear for Mr. Dananjaya and also, yeah, okay. He raised his thumb like this. Okay, so it's good. And Mrs. Chan, is that enough? I cannot see her. Is that good? The answer is, are you happy with the answer? Yes. Oh, good. Okay, nice. Okay, because we still have time, and I do believe Miss and I also still have time, like until 11:30. So I will open the third session for the discussion. Anyone who wants to ask questions for Ms. Mishra? Okay, or other speakers maybe? Yes, I see Ibu Dika Widyastuti and also one from the Master of Notary students. Okay.
Thank you, moderator. So I would like to address my question to Mr. Parikesit and also Dayuika. As we know that Indonesia already has several laws about information, technology, and etc. And also government has already take preventive measures for controlling the data misuse. So I'm talking about the data misuse or about the data usage violation. What is your ideas or what is your advice for the future regarding to the data misuse and data usage violation that causes losses to the data owner? So because this is so many problems now in Indonesia, I think about the misuse of data, which is give losses to the owner. Thank you.
Thank you. The second question. Yes. Di depan, Pak.
Thank you for the opportunity for me to make a question. I want to make a question for my friend Ida Ayu Saraswati. Was before you mentioned about the leaks of the personal data. If we talking about the cyber notary, there is we have to avoid the damage of the data. If we want to make a standard from the WTO or FTA or something, there's we have to make a trial and error for this. How we figure it out as a notary with the trial and error, because we have the data is so important. How we can figure it out about the trial and error for this? Okay, thank you.
Okay, thank you. So I guess I will give time for Mr. Vidya Teja first to give answer or comments and sharing your ideas about the issues that arise by Ibu Dika.
Thank you so much for the question. And yes, why we have to address the issue of the openness, the security, and also the privacy, because if there is no regulation about those things, what will happen if the data and the internet will be under control by the government and the giant corporation too? And the internet, especially the media, become the party the government can control the internet in terms of political reason. When we remember what was happening in old order and in the new order, some of you may remember that to control the public distress, they just simply take down the media. And what happened now in the era of information, then they can use this media, this tool, also to control the media. So that's why we need to make some detailed rules, filtering more cases content, and avoid the perception that the government just want to in terms of political, to control the media for political reason. And of course, waiting for the existence of international trade law require waiting period. But if Indonesia, I spoke about the international level because I recognize some international trade agreement have require regulation about the data protection and data security, and it could be a good point to start thinking about the regulation of data laws in international level. That's what I am understanding about this issue. Thank you.
Okay, so Ms. Mishra, do you have any statement concerning this issue?
No, no additional from my side.
Okay, so I will give the opportunity to Ms. Saraswati to respond the question from Mr. Yanwar. Time is yours.
Sorry, for Mr. Yanwar, can you repeat it once again regarding your questions before?
If we want to if we want to do like a WTO standard of FTA standard, it has to make a trial and error for this. The data, important data is not worth to make with trial and error. How do you not figure it out about that? Okay.
Okay, regarding of your questions, actually, I don't really know regarding about that trial and error systems. I never figure it out about your questions, but in my opinion, maybe how notary handle the trial, the damage of the data, and make a trial of error of that. Maybe it depends of the regulations first. The cyber notary is regulated in the ministerial regulations and also the government regulations first, and then the mechanism it's going to be regulated in that regulations, and also from the regulations is created, maybe we can know what is the real mechanism regarding the how to how to store the data, and also how to store the electronics data, informations, electronics documents or something like that. That's all. I'm so sorry if that is not really fulfilling your questions, but that's all I got. Thank you.
Okay, thank you very much. Well, this is a very interesting discussion. I opened three terms, and we got very interesting questions. And is there anyone through online or offline that still want to deliver questions to our speakers here? Because this is a very fruitful and important moment that we can hear the opinion or statement from Ms. Misra and then Mr. Widya Teja and also Dayu here. Anyone? Okay, so how about the online? Do you have any questions? I guess not. Okay, so you have additional questions? No problem, thank you. Please, time is yours.
Thank you, moderator. I will like to address my question now for Miss Neha. I would like to, I really interested with her slide, which is say that privacy and data protection rules can be both a trade barrier and also a trade enabler. Would you like to explain more about this condition when we can see the privacy and data protection rules can be a trade barrier or a trade enabler? Thank you.
Thank you. You can directly respond it, Ms. Misra.
Okay. So thank you so much for the question. The reason why I put it out there is because I think this is a very interesting dilemma that international trade law has to face. So now, as I mentioned in my presentation, different countries have different kinds of privacy laws, privacy and data protection laws, and many of these laws can be restrictive in nature. In the sense, so let me give you some examples. So there are quite a few data protection laws which impose regulatory requirements which are more burdensome for foreign service suppliers as compared to domestic service suppliers. So under international trade law, that would be a violation of the principle of non-discrimination because you are treating domestic suppliers more favorably compared to international suppliers. There are also regulations, for instance, the European Union's General Data Protection Regulation, where they allow data transfers to certain. So when you want to transfer personal data from the EU to other countries, there are certain countries which are called adequate. So you can transfer data to those countries freely, but you cannot transfer data to all other countries of the world, which the European Commission does not consider to be adequate. Now, that itself also could be a violation of the principle of non-discrimination because you are discriminating against certain trading partners. Again, that's a high-level principle in international trade agreements, and it is possible that a data protection law could violate that principle. There are also certain countries which have very strict requirements for storing and processing of personal data. So sometimes the requirement can be that you have to store data personally, or there could be a requirement that if you want to transfer data abroad, you need to get a lot of permissions or authorizations or licenses. Now, all of this also might implicate international trade law. Because either it might affect market access, so foreign companies who do not have local data servers may not be able to operate in that country, or if the licensing or the authorization requirements are unreasonable or not implemented in an objective manner, then you could also violate certain other international obligations on domestic regulations in WTO law. So these are the these are just some examples of how data protection laws can violate obligations in international trade agreements. And I also explained in my presentation they are economic trade barriers in the economic sense because companies have to spend a lot of money trying to adapt their business models to data protection laws of different countries. And in that sense, data protection and privacy can be a trade barrier, but it can be a trade facilitator because ultimately when we want to have digital trade, when we want a global digital economy, there has to be privacy at a global level. So if you're thinking of a free and open internet, you cannot have it unless every person who is participating in the internet is reasonably confident that their data is secure, that their data is not being misused, or there is no surveillance by big companies or governments. So at a global level, we still need privacy. So in that sense, privacy is a trade facilitator. But that, of course, would be a more global or transnational concept of privacy rather than a very domestic notion of privacy. So that's the reason why there is a tension between this domestic and international aspect of privacy. So that's the reason why I put as data privacy being a facilitator, but also being a barrier at times, depending on how the regulations are implemented. Thank you.
Thank you very much, Miss Hart. Okay, so ladies and gentlemen, I guess we not open anymore for the discussion sessions. When we see the allocations of time, I guess we only have several minutes. So I will give the opportunity to all the speakers to give the closing statement. For some of all of your presentations and also the questions and suggestions that addressed to you during this seminar. So yeah, I guess like 5 minutes for each. I will give the opportunity first for Ms. Misra, but if because I know I get informed that you really have to finish at 11:30. If after your closing statement you want directly to leave this seminar, it's really pleased. So before that, so on behalf of the committee, I will say thank you very much for your very fruitful and also very rich experience that you share here to us about you're willing to deliver your knowledge also for especially for our students as Master of Notary at the Faculty of Law Dayana University. I hope this is not the last time that you join us, but this is the first time that opened the other opportunity to have cooperation with you. Maybe next time the seminar that conducted from other program or even the students a community who will contact you. It's a pleased to have you here. So I will invite you to have your closing statement because after that I will deliver the opportunity to Mr. Widyateja and then from Mr. Dayu before I deliver the closing remarks. The time is yours, Ms. Nehra.
Thank you. So let me just start by just thanking again everyone, all the esteemed faculty members, all the audience members, people who have joined us online. I'm really honored to have spoken to all of you, and you are certainly right. I hope this is the first of many collaboration opportunities with all of you. I already told Patty that Patty knows that I'm a big fan of Indonesia and especially Bali, and Patty actually will vouch for the fact that I have visited parts of Indonesia that many Indonesians also do not visit. So I'm really hoping that this can be a very lifelong collaboration. I'm really honored to be a part of the dialogue. I'm not sure how I should end it, but I wanted to just send out a message that if anybody in the faculty or the student community would like to communicate with me, my email address was on my slides, and I'm sure Patty can give it to you as well. I would be delighted to talk to you, even if there were certain questions I could not address, or if you didn't get a chance to ask, or if you have a question later on. I'm available. I'm very happy to talk to all of you. I'm also happy to learn about your research. So if anyone is researching on Indonesia or generally in these areas, please share your work with me. We learn a lot from each other. It'll be a very fruitful, humbling, fantastic experience for me. So yeah, I just want to end my closing statement, which should be of gratitude and humility. So thank you so much for this opportunity.
Thank you very much. Would you please one time give applause for Ms. Neha Mishra. Thank you. Stay safe and stay healthy there. Hopefully we can meet you in person. Thank you. So the time I will deliver to Mr. Widyateja. Time is yours.
Thank you so much. And I also want to address my thanks to Neha. Thank you for sharing and have a good day in Tokyo. Enjoy the Olympic next month. with no social distancing there, with no mask. That's a great situation. I wish I could be there someday. Okay, to close my statement regarding about the regulation of data laws in Indonesia and particular about supporting digital trade. Of course, Indonesia need like two strategies, short-term strategies and the long-term. The short-term strategy, of course, the revision of ITE law should be continued, and after it has done, then it should be continued by issuing the good governmental regulation. So it should contain more detailed rule about the qualification of like a public disquiet or public order, so the government doesn't impose any restriction too easily, because whenever they want to impose the restriction, the digital trade also adversely impacted. In the long term, of course, we need the international level to regulate about the internet governance. So every country, every business entrepreneur, whatever their origin, can compete, can sell their product everywhere across the globe. So no more discriminatory, no more restriction in the international level in relation to internet governance. That's my closing statement. Thank you.
Thank you very much. Would you please to give big applause also? Terima kasih Pak Sigit. And then Dayu, time to you to deliver your closing statement.
Okay, thank you so much for the opportunity that is given to me. So this the last statement of my presentations. So of course, the concept of cyber notary can ease the task of the notary itself, and especially in carrying out the main task of his positions. Namely, one of them is related to the notary's obligations to keep the minutes of the deed that he has made. And nevertheless, and we also see the need to the follow-up on the elucidations of Article 15, paragraph 3, related to the notary authority to certify the electronic transactions. Notaries have to wait. Do notaries have to wait the issuance of the government regulations, or is it enough to existing ministerial regulations to facilitate this? So cyber notary actually provides an opportunity for notaries to have the authority to store documents, electronic documents, and of course, because of this, it is really it's really have a bad potential also for the cybercrime, so on and so on. So the protection of personal data is important for spatial and comprehensive regulations to be made in the future. One of which is to support the provide legal certainty for cyber notary practices in Indonesia and provide legal protections to parties who use notary legal services, especially in personal data protections. Okay, that's all my statement. Thank you.
Thank you very much. So, thank you for all the speakers. For me, it's really hard to give like a closing remarks because they already deliver closing statement very well. But if I can say the seminar with the title "The Regulations of Data Laws via International Trade Law," it's a very interesting moment for us because honestly, maybe the discussions about the data laws is not very common here. I mean, like this seminar will help to arise the awareness about how important, and a lot of people out there, it's really concerned about this. So, because if we can see the speaker from Ms. Misra delivering about how to regulate, like the regulating data via international trade agreements, digital trade, cyber security and privacy governance. It's give like a big pictures about the situations at the global level. And if I can quote, like she deliver many things, but the things that really hit me, if I can say, like I do realize how important about the developing the interinstitutional linkage, and then also the policy innovations and the scope of experimentations. It indeed, that's for me that the most important situations that we have to prepare. It really have a close relations with what the presentations delivered by Mr. Widya Teja in digital trade and the regulations of data laws in Indonesia. After get a big picture from Ms. Mishra, Mr. Parikesit Widyateja bring us to take a look about situations, what happened here in Indonesia, and how the government anticipate the situations that, if I can say, is running very fast when we're talking about the data laws itself. Because here in Indonesia, we still have many challenges, especially about the misuse and also the security and how the government will handle it. I mean, like the regulations that we have here, it's still, if I can say, it's a bit difficult to catch up with all the situations that happened. So that's why Mr. Parikesit given emphasize that the government need to establish the detailed rules, and also filtering more cautious content and minimize the first impact of digital economy. And also he mentioned that we still have challenges that we have the government and also us as a society to be deal with in the future, because we cannot say like we are the ordinary people, we don't really have the connections with what happened in law or what happens in the abroad situations about the digital laws itself. And because this seminar is conducted or organizing by the Master of Notary Programs, we are having Dayu that address the issues about how to link the issues about the data laws here, and also the positions of the notary. Because maybe you already know, Ms. Mishra, the notary is one of the very prestigious profession here in Indonesia. So if you ask the students of the faculty of law, most of them will say that they really want to be a notary, because here the privilege that have by a notary is, it's really how I can say, it's like a dream for most of faculty of law students. They will have their own office, they will wear a very nice dress, and people will come to them, because like the regulations, the legislations mentioned that people have to come in front of the notary, not the notary come to the people. So they have a very high rank here. So that's why you deliver the connection, the issues about the connections, about what is the challenges for the notary in this current situations, that they have to deal with the electronic certificate, that it's gonna be very difficult for them also how to adjust it, because all the data about the parties that involved in their deed is most of it is very secret. They have to really manage the security of the security and the safetyness of the data that they have. So maybe this also will open the mind, and also it's like the first step for the Faculty of Law Dayana University to have more discussion, to have more seminar to discuss about these situations. And especially the pandemic situations is give us the situation that we are more depending to the internet, and also the data laws in a broader ways. Okay,
So that's my closing remarks. Once again, I will say thank you very much for Master of Notary program. We have still the head of the coordinator here, Professor Rimade Subawa. Thank you very much for the opportunity for me to chair these sessions, and also thank you very much for all the speakers, Ms. Neha Misra, who joined us from Tokyo, and then Mr. Parikesit Vidya Teja and Aisara Swati, and all the participants who join us via online or have time to join us here at the Aula Faculty of Law, Dayana University. Thank you very much for the hard work for the committee also. Would you please give a big applause for all the committee? And the chair of the committee, Bu Dr. Suksma Prijandini, I think you can feel so released now after 2 days running international seminar. So once again, thank you very much. I apologize if in the time I'm chairing this session that cause any inconvenience. Okay, I will close it with Parama Santi, Om Santi, Santi, Santi Om. Thank you. I will give it back to the MC.
Distinguished guests, ladies and gentlemen, now we'd like to give the seminar gift to the speakers. For the speakers, Mr. Igusti Ngurah Parikesit Widya Teja, SHM Hum LLM PhD, and Ida Ayu Saraswati SH. For the moderator, Ms. Nigusti Ayudhya Satyawati SH MKN LLM, please come to the stage. To Professor Dr. Imade Subawa, SHMS, as Coordinator of Master of Notary Program, please come to the stage. Thank you. Excellencies, distinguished guests, participants, ladies and gentlemen, we are entering the end of the seminar today. We already had fruitful and warm discussion during the seminar. On behalf of the committee, I would like to say thank you very much for your attention during the seminar, and we apologize for all the inconvenience during the seminar. Hopefully, the seminar will be beneficial for all of us. We will close with Parama Santi. Om Santi 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 Om.